Hi, I'm Greg Brown. Today we're going to talk about an agreement to agree. That is, instances where the parties to a contract or agreement require a written contract as one of the material terms. First, let's go through a little bit of background. Generally speaking, a contract does not need to be in writing to be valid or enforceable under California law, except when the subject matter is subject to the California statute of frauds, like a contract for the sale of real estate. Now, the statute of frauds is the subject of a separate video that you're welcome to look at afterwards. So anyhow, where the parties intend that an agreement be reduced to writing, a written agreement is necessary. First, before an oral or written contract is formed by the parties, all of the elements of a contract or contractual agreement must be met. So creating a contract requires that 4 elements be satisfied. First is mutual assent. Second is the capacity to contract. Third, a lawful object of the contract. And fourth, consideration. Now, that's subject to another video as well. But generally, mutual assent means that the parties come to an agreement on all material terms of the contract. A material term is one that concerns significant issues, such as the subject matter of the contract, the price, the terms of payment, etc. But what if the written agreement is actually a material term? That's what we call agreements to agree. And in California, they're not binding. Nor are preliminary negotiations the same as a valid agreement. Therefore, where the parties intend to put their agreement into a signed writing, no contract is formed, no written contract is formed until that later written agreement is executed by the parties. Failure to sign a subsequent written agreement means that no written contract exists, except maybe an oral contract, which is subject to another video. Whether the parties have created a binding oral contract or merely an agreement to agree at a later date depends on the surrounding facts and circumstances of each particular case. Key evidence in these situations include the actions taken by the parties. Now, for more information on this topic or any other topics concerning your business or contract issues or related issues, call us here at Brown & Charbonneau at 714-505-3000 or email us at inquiries@bc-llp.com. Thank you.